The trial of Mr. Ruto and Mr. Sang opened on 10th September 2013 at the International Criminal Court. It will continue next Tuesday, 17th September 2013, in the presence of the accused. The hearing is scheduled to start at 9:30 a.m. The Hague local time. During the hearing, the first witness called by the prosecution will give testimony. Who can be a witness before the court? How are witnesses important to the judicial process?
Like in national judicial systems, the presence of witness is crucial for the judges to be able to establish the truth. So their courage and determination to testify and to explain what they have seen or what they know before the judges is something that is very important and essential for the judicial process. A witness, in general terms, is a person who have an information that is relevant for the case or for the question that is presented before the judges, whether this person is an expert or maybe a victim or a person who have seen an event and is able to testify and to explain it to the judges.
What is the difference between a witness and a victim? How are witnesses selected? Are they paid by the court?
A witness is a person who has an information and is willing to explain it to the judges, whether as an expert, as an eyewitness, or any other person who have this information or knowledge about an event that is relevant for the court. A victim is a person who have suffered a harm as a result of a crime that is prosecuted before the International Criminal Court. So they are not the same thing. A victim may be called as a witness, but it is not necessary that every witness is a victim, and not every victim will be called as a witness. The witnesses are called by the prosecutor or by the defense. They can also be called by the legal representative of the victims or by the judges. They are not paid for their testimony. Testifying before the court is participating to the establishment of the truth, and this cannot be paid. Of course, the court will cover their expenses in case they will have to travel to be present before the ICC, but they are not getting payment in recompensation of being a witness before the court. The victims have completely different role and different status before the ICC. The victims are authorized to participate through a lawyer who is their legal representative. And this lawyer is the person who will be presenting to the judges the preoccupations of the victims and explaining to the judges the stories of the victims and defending their personal interests. Also, the victims can ask for reparations only if the accused has been convicted by the judges after the trial, and these reparations can be financial but can be symbolic. It can be individual reparations and can be collective reparations. And as I said, this is completely different from the issue of the witnesses, who may be victims or may not be victims, and in any case they are not getting paid for their testimonies.
Is a witness credibility assessed before they give testimony? What would happen if a witness gives a false testimony?
There are several measures that are implemented by the court in order to ensure that the witnesses will not be giving a false testimony, starting from their undertaking to tell the truth before the judges until the end of the trial. Of course, it's only for the judges to assess the credibility of all the evidence, including the testimonies of the witnesses. And in accordance with the Rome Statute, a false testimony can be prosecuted, and the sanction of it would amount up to 5 years of imprisonment and or a fine. And as you know, every witness who will be testifying before the judges will be questioned by the prosecutor, let's say, and then will be cross-examined by the other party, which is the defense, or vice versa if this witness is called by the defense. Also, the judges and the legal representative of victims may also be putting questions to the witnesses, and all that will help the judges to establish the truth and will help them to be sure of the credibility of the testimony that is put before them. And on the other hand, also intimidating a witness or bribing a witness, trying to push a witness to give a false testimony, is also a crime that can be prosecuted under the ICC statute, but also under the Kenyan laws as well. And the ICC prosecutor has indicated that she is collecting some information about attempts to intimidate or to bribe witnesses, and she will decide to put it to the judges when she deems that appropriate.
How does the court protect witnesses? Are they also protected inside the courtroom?
The ICC has a protection program for the witnesses because the witnesses have a crucial role in the judicial process because they help the judges to establish the truth. So they need to be ensured of their safety and their well-being, including their psychological well-being. And the ICC offer these protective measures to allow the witnesses to feel confident enough to tell the truth to the judges. These protective measures can be ordered for the benefit of witnesses, whether they are called by the defense or by the prosecutor in an equal and completely neutral way. There is a specific unit at the ICC registry, which is the neutral organ of the court, that is in charge of protecting the witnesses and with the different protective measures that are necessary, starting from advising them on how to be discreet and confidential about their relation with the ICC, helping them ameliorating their own security if they are staying in the same place, being allowed to have a rapid intervention if necessary, and also medical care if it is necessary. And as an ultimate protective measure, there is a possibility for the court to relocate the witness, whether on a temporary basis or permanently, whether inside the same country or in another country. But since this is a heavy burden for the witness, for his or her family, as well as for the court, this is why the relocation is really the ultimate and last resort protective measures that can be ordered. Protective measures can also be implemented inside the courtroom. And this can be implemented, for example, by keeping the anonymity of the witness, by blurring the face on the image when we are web transmitting or transmitting by video the images from the trial room. And also by distorting the voice of the witness. Other protective measures can be also included to protect the psychological well-being of the witness, like allowing a lawyer or sometimes a member of the family to be present next to the witness to help the witness feeling confident and open to tell the truth to the judges. Once the witnesses arrive to the ICC, we offer them a familiarization with the courtroom and with the process, because a lot of witnesses may have never been in a courtroom before and might feel intimidated in front of a number of people and judges and lawyers. So they have to pass through this familiarization to know what they will be facing, who they will be facing, who will be sitting in front of them or at their right or at their left, and all that help them to be more confident in order to tell the truth to the judges. This familiarization process is not at all linked to the content of their testimony. No one will intervene with the content of what the witnesses have to say to the judges, but it's only put in place in order to allow them to feel confident to tell the truth and secured enough to tell the truth.
How does the Office of the Prosecutor interact with witnesses?
The Office of the Prosecutor respects the highest standards of professionalism in interacting with the witnesses. It's important for the court as a whole that the witnesses are confident and able to tell the truth to the judges. It's only the judges who will be able to assess the credibility of the witnesses once they have listened to them, answering the questions that have been put by the prosecutor and by the defense, Sometimes if the representative of the victims are allowed also to put questions, then the witnesses will be answering it, and also if there are questions by the judges. So it will be only for the judges to assess the credibility of the witnesses. Witnesses are familiarized with the process. This is something that is a general process, a standard process that we apply to all the witnesses, whether they are called by the prosecutor or by the defense. And the purpose of this familiarization process is only to allow the witnesses not to be intimidated by their presence inside the courtroom, and to be able to feel confident enough to express and to tell the judges the truth about the information that they are asked about.
What will happen to the cases if there are no witnesses for the prosecution side?
It is important to stop speculations about the outcome of the trials, because we are only at the opening of the trials at this stage. A large number of witnesses will be called by both parties, and large number of documents and evidence will be presented to the judges. Some of these documents are confidential. Some of the testimonies will be in closed sessions. So only the judges will have the full picture and will be able to assess the credibility of all the witnesses and to assess what is the solidity of all the evidence, and based on that they will make their own decisions. So it's important to let the pursuit of justice continue for the benefit of Kenya, for the benefit of the victims in Kenya, and for the benefit of justice and how it helps in creating a lasting peace.